Very good afternoon, viewers. I'm Dr. Rajesh Singh, Associate Professor from Parul University, Parul Institute of Law. I warm welcome our Honorable guest Rajiv Kumar Bansal, who is advocate on record from the Honorable Supreme Court. Sir, we welcome you on this virtual platform and virtual webinar, sir. About Rajiv Kumar Bansal, sir, let me just give a brief description about sir. Rajiv Kumar Bansal, sir, is a senior advocate on record in the Supreme Court. He belongs to a juristic family of Uttar Pradesh. His father, Sri Om Prakash Bansal, was very popular judge in Uttar Pradesh, who was also known for his intelligence of and hardworking and legal acumen. Rajiv Kumar Bansal, sir, has first did his MBA and then LLB. Before joining the legal profession, Rajiv Kumar Bansal, sir, did job in the private organization, and due to his interest in the legal field, he finally switched over to the legal profession in 1999. He started independent practice since 2001, and he has become advocate on record in Supreme Court in 2006. He was also elected as the Joint Secretary in the Supreme Court Advocate on Record Association in 2008. He did so many reported cases where stepping stones that eventually led to the establishment lawyers in the Supreme Court. He also worked earlier in the Council for the Government of India and is now active lawyer for many governmental panels, several times panel advocates. Several times he has been appointed amicus curiae in many cases before the Honorable Supreme Court. So we welcome on this platform, sir, and the topic of this webinar is the basic features of the Indian Constitution, which is very interesting topic. And sir, let me speak about our Dean, Dr. Akhil Syed, sir, who is the Dean and Director of Parul Institute of Law, Parul University. He is the first PhD holder from Gujarat National Law University. He is having, sir, 6 research book and 6 project in his name. He has already presented around about 50 to 60 papers in the various conferences, and he is the young and dynamic Dean and Director at this Parul Institute of Law, Parul University, and is very hardworking, sir. So, sir, I just tell Dr. Akhil Syed, sir, to warm welcome Advocate Rajiv Kumar Bansal, sir. Dr. Akhil, sir.
Thank you, Dr. Rajesh. Thank you very much. Honorable Advocate Shri Bansal Saab, I on my personal behalf, on behalf of Parul University and Faculty of Law, welcome you. It's our great pleasure that a personality like yours is on the virtual platform of Parul University today. That has been a tradition of Parul University to invite eminent scholars from the various fields at the Parul University for the benefit of not only the students but also the society and public at large. Because this is the time of pandemic when regular teaching is not been available to many of the students. Though the Parul University continue with the online education, so we also impart the education and knowledge to the students who have not registered at the Parul University. Parul Institute of Law was been established in 2016 with the second amendment into the private university, Gujarat Private University Act 2015. And since then, university has established this faculty of law with 3 programs in 5-year integrated course, that is BA LLB, BCom LLB, and BBA LLB. Thereafter, we started 3 years LLB program as well as 1 year PG LLM program. And I have a pride to share that we do have 6 different specializations we offer for the 1 year LLM program. In addition to LLM, we do have MPhil and PhD program in law. And that is how the whole of the faculty of law is been involved into academics and research. And my colleague like Dr. Rajesh is continuously involved in continuing legal education also, in which not only the students but also the people from the bar are also benefited through the faculty of law, Parul University. I once again welcome Bansal Saab and invite him, take an opportunity to invite him at the Parul University premises whenever the situation gets normal and the students start attending the college. Sir, I request you to visit at least once at our university and bless our students. Thank you, sir. Thank you very much.
Thank you, Dr. Akhil sir, for the warm welcome to sir. Now, on the behalf of Parul Institute of Law, Parul University, I, Dr. Rajesh Singh, now handing this session to Advocate Rajiv Kumar Bansal sir. For this session, sir, at the last 10 minutes, the student will ask certain questions, sir. I will put up to you so that you can give the answer. So this session is now to you, sir.
Okay, okay, Rajesh. Can I speak? Start? Can I start?
Yes, sir.
Yes, please.
Thank you, Dean, Faculty of Law, Rajesh, Assistant Professor of Law. Today, I am here to speak on laws on basic features of Indian Constitution. Laws on basic features of Indian Constitution is a very interesting subject and very knowledge-gaining subject which students should know about Indian Constitution. First of all, when we start this topic, here are some things which I feel that students and other people should know about the things so that they can impart their knowledge and decide the things very well in the proper manner. Now, rather straight away coming on the topics, I am saying few things which are imperative to know this subject and this topic to understand well. First of all, I would start from Article 13 of Indian Constitution. In a very simple language, if I would interpret Article 13, then I can say Article 13, it directs that all laws which are inconsistent with or in derogation with the fundamental rights shall be declared void. I think this is a very simple thing. You students can also understand in the manner that prior to Constitution came into the force on 26 January 1950, there were some existing laws. These laws were existing prior to 1950, 26 January. And when our Indian Constitution came into the force, fundamental right, which is the soul of Indian Constitution, part, very, very important part. So Parliament and government and constitutional framers wanted this thing that time that fundamental rights should not be disturbed at all. So that if any laws which were existing and inconsistent to fundamental right shall be declared void. So that objective is that prime objective is the supremacy of fundamental right. Fundamental right is a bone of this Indian Constitution. It should. This is the thing which we can understand. We can rather in this subject, Article 13. If you go through the books, you will get the lengthy Constitution language also. I also give you that also. Article 13 says in book language, if you go through, all laws in force in the territory of India immediately before the commencement of the Constitution, insofar as they are inconsistent with the provisions of this part, shall to the extent of such inconsistency be void. I think I have cleared my thing that main important thing is our fundamental rights, which are born of our Indian Constitution. Second thing is the state shall not make any law which takes away or abridges the right conferred by this part, and any law made in contravention of this clause shall to the extent of the contravention be void. So I have explained Article 13 and I very clear that students easily understood this thing, that the primary focus on fundamental right, that this should not be disturbed at any cost, at any price. Now, second thing, before starting and coming on the basic features of Indian Constitution, that is Schedule 9. This is also very important when we talk about the basic features of Indian Constitution. 9 schedule, so far is we say 9 schedule in a very simple and understandable language. 9 schedule basically contains a list of central and state laws which cannot be challenged into any courts. Currently 284 laws which are away from judicial review procedure and shielded from judicial review. 284 laws are there this time. The schedule became a part of Indian Constitution in 1951. Practically, the 9th schedule of the Constitution is where the government parks the laws where government want that no one should disturb this. Even the beyond, if government thinks it should be beyond judicial review, even the Supreme Court also. So 9th schedule was formed in 91 due to this, for this purpose. This 9th schedule was framed by Nehru government in 1951, and it emanates from Article 31A and 31B, which were introduced by the Constitution First Amendment Act 1951. With effect from June 18, 1951, ensured certain laws were valid even if violated the fundamental rights of the citizens. Later on, we will come, some changes is also there, but after the lecture, we will come on that. So now we are touching the topic, but prior to that, I would like to say you, in Indian Constitution, when it came into the force, there were 395 articles, 8 schedules, and it was divided into 22 parts. If we talk as on today, I suppose that there are 470 articles, more than 470, 12 schedules, and it is divided into 25 parts. So one can easily understand that time to time, government to government, this was the feeling that there should be some change, there should be some amendment, there should be some changes according to the demand, there should be something so that anyone can easily access this thing, that due to the time and something changes, these all things came, so that we came 395 to 472, 9 schedule to 12 schedules, and 22 parts to 25 parts. Now, if we talk about basic features of Indian Constitution, basic features, as we know that the Indian Constitution is the bulkiest constitution of the world. And basic features on Indian Constitution, if we write, what are these basic features? What are the basic features of Indian Constitution? Preamble. You can ask, preamble is basic feature. Fundamental rights, basic features. Secularism is basic features. Rule of law, basic features. Independence judiciary is a basic feature. Democratic government is basic feature. So liberal democracy is basic feature. So these are the basic features which should not be destroyed. Now, if we will start laws on basic features of Indian Constitution, this has already started the things from 1951. When Shankari Prasad versus Union of India, one judgment came by the Supreme Court that was popular as Shankari Prasad versus Union of India. Shankari Prasad was the landowner in the Bihar. There were 2 laws came, 31A and 31B. 31A and 31B. 31A, if we talk about 31A, so far as 31A is concerned, according to it, government, in very easy language, I am not on language which is prescribed in the books. Government can take anyone's land for the public purpose if he feels that it is in excess. And 31B is that if you make any law or keep that law in Schedule 9, then no one can change it. So here what the thing was, 31A will take your land And 31B says that if 31A law which is capped in 31A, that cannot be changed, then you are handless. You can't do anything. 31A and 31B. So Shankri Prasad, who was the landowner in the Bihar, who understood the things and basically tried that how we can give our land to the government. So he challenged this virus of 31A and 31B. And finally, this from High Court to the Supreme Court. I am directly coming on the judgments, basically paucity of time, so that we cannot complete our all things. So Shankri Prasad versus Union of India, Supreme Court decided this thing and laid down that the amendment was not law for the purpose of Article 13. You can easily understand that amendment is not law for the purpose of Article 13 means Article 13 we have already gone through. Article 13 says that inconsistencies with fundamental rights shall be declared void. Here we say if anything law which is not law for the purpose of Article 13, that means that it is a law which you cannot change it. So in easy language you can understand is, if you say that Article 13 as it's not every amendment is not law for the purpose of Article 13, so you can save yourself basically. And Supreme Court held down that every amendment is not law for the purpose of Article 13, and therefore the Parliament under Article 368 Constitution of India has the power to amend any part of Constitution of India, including fundamental right. So as per Shankri Prasad, this was laid down by the Supreme Court that in Article 368, under section Article 368, Supreme Parliament has the power to amend any part of Indian Constitution, including fundamental right. I think I have cleared this, Shankri Prasad. Here was the law is that every amendment was not law for the purpose of Article 13. Now, somehow in 61, there is a one popular case, that is Sajjan Singh versus State of Rajasthan. Sajjan Singh was a sub-inspector. He was appointed by the Inspector General of Police, Rajasthan. And he was confirmed by the Inspector General of Police, Rajasthan after some times. But in a disciplinary inquiry, he was dismissed by this DIG, Deputy Inspector General of Police. So Sajjan Singh has made this issue, and on the issue, Sajjan Singh said that the plea was that under Article 311 of the Constitution of India, a person cannot be removed from service by an authority subordinate to it, by an authority subordinate to that by which he was appointed. As everybody knows that law exists those who are vigilant, not those who sleep over their rights. So I always favor this thing that if you are vigilant, you can, as law will assist you. And if you are asleep over your right, then you will not get anything. So Sajjan Singh made this issue, and finally Sajjan Singh succeeded this issue. And finally judgment was that in 311, the lowest authority from that he was appointed by the Supreme Authority cannot be dismissed under Article 311 of the Constitution of India. So Sajjan Singh case, Supreme Court reiterated the same law which was held in Shankri Prasad versus Union of India. In Shankri Prasad versus Union of India, same thing here also. Here minor change was under Article 368. Here the Supreme Court held in Sajjan Singh. Under Article 368, 368 confers the Parliament the right to amend the Constitution. The power in question can be exercised over all the provision of the Constitution. So mean that the things are same. Even then Shankri Prasad and Sajjan Singh versus State of Rajasthan. that everything can be done by Parliament. Now, in 64, Golaknath versus State of Punjab, a very leading cases. This case was heard by 11 judge bench, and in 1967, the judgment passed by the Supreme Court, which is a very important judgment and a very remarkable judgment also. What was this? This case also again was the landowners. As by there was an act, Punjab Security and Land Tenures Act 153. Landowners were again scared of losing their lands. In Golaknath, the court with majority of 6-5, there is only one dissenting judge, concurring judge, sorry, held that a constitutional amendment was also law. Here, this Golaknath overruled Shankari Prasad as well as Sajjan Singh versus State of Rajasthan, and held that a constitutional amendment was also law for the purpose of Article 13, and also held very important thing that Parliament cannot do any kind of amendments in fundamental rights. I would like to say some bookish language also here that is important for students. There were some questions which were in whether amendment of the Constitution under Article 368 is law within the meaning of Article 13(2). So, response is yes, it is law. Earlier it was not law. In Golaknath, it was decided it is law. Second was whether power of amendment given by Article 368 also includes the power to abrogate the Constitution completely and to replace it by entire new Constitution. So response, you know. The third is whether there are any implied limitation on the power of amendment contained in Article 368. And fourth question, the scope of amending power under Article 368 of the Constitution is valid. So response, you know, when Article 368 you say that every amendment is law for the purpose of Article 13. So that Parliament cannot do any kind of amendments including fundamental right. So this is all the things whether the Impugn Act insofar as purports to take away or any of the fundamental rights conferred by Part 3 of the Constitution falls within the provision of Act Article 13(2). So finally, the judgment of Supreme Court very clearly held, and response to in these all questions, there was a one conclusion, that was constitutional amendment was law for the purpose of Article 13, and Parliament cannot do any kind of amendments in fundamental rights. Now, finally, we have come on the historical judgment of Supreme Court, Keshwanand Bharati versus State of Kerala. Keshwanand Bharati versus State of Kerala. Keshwanand Bharati versus State of Kerala is a Supreme Court judgment which is popular as basic structure doctrine case. Basic structure doctrine case. It was laid down by the Supreme Court. This was the 13-judge bench decision. And if I rightly remember, this case was heard for 68 days. This case was argued for 68 days. And judgment was consist of more than 200 or 200 pages. This was the lengthiest judgment at that time in those days. Now, what is Keshwanand Bharati? So, brief facts if I will say to you. Writ petition basically was filed by Keshwanand Bharati on March 21, 1970 under Article 32 of the Constitution for enforcement of his legal rights, fundamental rights, under Article 25, 26, 14, 19, 1F and 31 of the Constitution. He prayed that the provisions of the Kerala Land Reforms Act, here this is important, 1963, as amended by the Kerala Land Reforms Amendment Act 1969 to be declared unconstitutional, ultra-virus and void on the ground that some of its provision violated the fundamental rights. Now, important thing is, during the pendency of this writ petition, Parliament passed the 3 constitutional amendments, 1, 24th, 25th and 29th. As the petitioner apprehended, Keshwanand Bharti apprehended that he would not succeed in view of the above amendments, he also challenged 24, 25 and 29 amendments also. The Constitutional 24th Amendment Act, Amendment Article 368 is enacted that Parliament may, in exercise of its constitutional power, amend by way of addition, variation or repeal any provision of the Constitution in accordance with the procedure laid down in that article. Other parts of the amendment is that nothing in Article 13 shall apply to any amendment under Article 368. So far as 25th Amendment was concerned, 25th Amendment, Section 2 of the Amendment Act substituted the word amount for the word compensation and excluded the application of Art 19(1)(f) to a law under Article 31(2). It was also made clear that no such law shall be called in question in any court on the ground that the whole or any part of such amount is to be given otherwise than in cash. So that you can understand this in other way also. And finally, the Constitution 29th Amendment Act included the Kerala Reforms Act scheduled to the Constitution, making them immune from attack on the ground of violation of fundamental rights. So if we assess all the things and conclusively and cumulatively, if we say that only one question of law was involved. What that was question of law? The extent or scope of amending power of Parliament contained in Article 368. Now, Keshwanand Bharti, if we see Keshwanand Bharti, then Keshwanand Bharti, we see the judgment of Keshav Bharti. Supreme Court basically held constitutional amendment was not law for the purpose of Article 13. The same thing which was held in Sankri Prasad, which was held in Sajjan Singh. Now, Golaknath overturned all the things. Again, Keshwanand Bharti again reiterated the earlier things that for the purpose of Article 13. But one more thing, very important thing, Supreme Court has decided. What that thing is, Parliament can do. Please listen carefully. Parliament can do amendments in fundamental rights. Very easy language. Otherwise, in books, when we go, there is not so easy language. Parliament can do amendments in fundamental rights. Pro-amendment procedure. But the basic features of the Constitution should not be destroyed. So finally, this law, basic doctrine principle, basic structure doctrine is on today is also in force. We are applying this basic principle in so many places also, and we have applied it also. If there were 4 cases like Indira Gandhi, if I say Indira Gandhi versus Raj Narayan. So I will go facts through this. This is a case, Indira Gandhi versus Raj Narayan. This is a case where the basic doctrine principle, basic structure doctrine principle was applied. How? I tell you. This is AIR 1975. This is a case regarding election disputes involving the Prime Minister at the time and purpose of 39th Amendment in the Constitution. Facts, brief facts. So facts are not so very important, but everyone should know the basically what was, why the case was filed and why it was the objective. Raj Narayan had contested the Indian General Election 1971 against Indira Gandhi, who represented the constituency of Raebareli. Indira Gandhi was re-elected. There, Raj Narayan filed a petition to appeal that verdict, alleging that Indira Gandhi used bribery government machinery and resources to gain an unfair advantage to board game, as she was prime minister earlier. So these were the all allegations on her. So far, this case is concerned on July 12, 1975. Here, the High Court judgment is also very important. Reason is, Justice Jagmohan Lal Sinha found Indira Gandhi guilty of electoral malpractices, and Justice by verdict declared election null and void. That's a very popular judgment in Indira Gandhi's prime ministership history, and barred Indira Gandhi from holding elected office for 6 years. Indira Gandhi, just you, every student of law should know that time that India emergency was around, and Indira Gandhi appealed in the Supreme Court. Meanwhile, appeal in Supreme Court. 39th Amendment, in this process, 39th Amendment Act was passed, and one new article 329A the Constitution of India was enacted. What is 329A? 329A says election of prime minister and election of speaker cannot be challenged in any court in the country. So, election of prime minister and election of speaker cannot be challenged in any part of the country. So that this is a case that if you are wrong, then you are wrong. You are right. You are right. Nobody can challenge you. So this case finally came to Supreme Court. Supreme Court main question of law which were framed. There were so many questions, but due to paucity of time, I am not going into every question. The main question was whether or not clause 4 of Article 329A of the Constitution of India was constitutionally valid or not. Supreme Court heard this matter, and that time it was a very popular matter. This was a matter of Prime Minister of that country. Honorable Supreme Court applied the basic structure doctrine laid down by Supreme Court in the Keshwanand Bharti versus State of Kerala. Please listen the language. This is book from book. It is stated that clause 4 of Article 329 is liable to be struck down on the ground that it violates the principle of free and fair election. Obviously, it is basically violates the principle of fair and free elections, which is a part of basic structure of the Constitution. When you say that no one can challenge the speakers and prime minister's election, so that this was prima facie looking that it violates the principle of free and fair election. So this was Supreme Court. But there was some judgments in Supreme Court which is important. The Supreme Court held clause 4 of Constitution 39th Amendment Act 1975 as unconstitutional and void on the ground that it was outrightly denial of the right to equality enshrined in Article 14. It was held by the court that these provisions were arbitrary and were calculated to damage and destroy the rule of law. Nothing more than that. So finally, but the judgment of Supreme Court was, I will not going into the things, but the things fact is, election of Indira Gandhi from their constituency library was considered to be valid. So far, this question, this is Indira Gandhi election was considered to be valid, but the Supreme Court in this case added the following features in the basic features to the list of basic features laid down in Keshwanand Bharti case. What is that? Rule of law. Second, democracy that implies free and fair election. Judicial review and jurisdiction of Supreme Court under Article 32. So you can easily understand this thing, how the things based on basic structure doctrine of Supreme Court, which we are now applying these also even Indira Gandhi Rajnarayan, even as on today also. But one case also is very important, that is Minerva Mills versus Union of India. Minerva Mills was a textile industry, and in the state of Karnataka. This was a cloth industry. In this case, the main issue before the court was to check constitutionality of 42nd Amendment 1976. The landmark judgment came somehow in July 1980. The judgment was divided into 4:1. One Justice Bhagwati was of dissenting note. Justice Bhagwati majority struck down section 55 and 4 of the 42nd Amendment as it was in violation of basic structure, thereby upholding the basic structure doctrine laid down in by Vishwanand. So this was the case where the Vishwanand Bharti basic principle was applied. The court held that section 55 of the Amendment Act 1976 void, since it firstly made challenge in court impossible. Challenge in court impossible, and secondly, it removes all the restrictions on the power of parliament under Article 368. These two things were there. This is a easy language. This is a proper language which students can easily understand. The court, relying on Keshwanand point that the power to amend under Article 368 is not a power to destroy. Article 368 is not meant for the power to destroy. Therefore, the court by 4:1 majority, 4:1 majority had held section 4 and 55, which arose from the 42nd Amendment 1967, unconstitutional. I would like to say your some Minerva Mills. So this is the basic Minerva Mills. This was the case, and finally the case which is very important, that is now we feel even Hero case. This is a case now very recently, you can say recently in 2007, when Justice Sabharwal was Chief Justice. That time this judgment came, and if you say this case can be very notable, remarkable, and it is known and popularly known as 9th schedule case. Iyer Coelho case is popularly known as 9th schedule case. This judgment was obviously delivered by a 9-judge bench also. 9-judge bench delivered an unanimous verdict. This was an unanimous verdict. This is a very important thing. On January 1st, 2007. This judgment upholding the authority of the judiciary to revive any law which destroy or damage the basic structure as indicated in Article 21, read with Article 14, 19, and the principles underlying thereunder, even if they have been put in 9th schedule after 14th April 1973. Keshwanand Bharti date, according to. This case is popularly known as 9th schedule case. So you can easily understand this. This case is known as 9th schedule case due to the politics involved and the exhaustive discussions on the validity of Article 31B of Indian Constitution. Before starting, I already told you what is 31B. When we want no one disturbed any law, government, parliament pass that law in 31B, in so that in 9th schedule, if you pass some laws, judicial review can't do this thing, that thing. Now, Iyer Coelho versus State of Tamil Nadu, there are some 2-3 things are very important. In this case, a member 9 judges bench of Supreme Court held 9 schedule items are not immune to judicial review as it is part of the Constitution. The 9 judge benches held that 9 schedule items are not immune to judicial system as it is part of Indian Constitution. So here, from beginning to end, there is something changed. Now judges saying that we can do judicial review also. Further, in the 9th schedule can abrogate fundamental rights as they form basic features of Indian Constitution. If we say that fundamental rights are the basic feature of Indian Constitution, so the Supreme Court held that 9th schedule can abrogate fundamental rights. Third thing, the objective behind Article 31B of the Constitution is to remove difficulty, as not to wipe out judicial review by Supreme Court. Supreme Court said that when 31B was enacted, its main purpose was to remove difficulties and not to wipe out judicial review from Supreme Court. So Supreme Court can't do anything. There was no objective. Supreme Court says this. Therefore, every amendment to the Constitution, including amendment to the 9th schedule, has to be in accordance with the basic structure doctrine. Finally, the thing is that everything which is rotating around basic structure principle. So finally, 9-judge bench, I.R. Coelho, very sad. Every amendment to the Constitution, including amendment to the 9th schedule, has to be in accordance with basic structure doctrine, which has been decided in the Keshwanand Bharti case. Keshwanand Bharti case says that you can do, but in accordance with law. So that this is the main question. So from there to here, we have come on the so many things which has come to now. So finally, basic structure doctrine is now from Keshwanand Bharti is in force now. That very clearly says that Parliament can do amendments in fundamental rights through amendment procedure, but the basic features of the Indian Constitution should not be destroyed. So finally, we have seen this thing that when 1951 Shankari Prasad judgment was that every amendment was not law for the purpose of Article 13. Sajjan Singh reiterated the same thing about the other minor difference. Golaknath overruled these two things. Golaknath said that every amendment is law, and finally Keshwanand Bharti case came that says no, every amendment is not law. Then we have seen that Indira Gandhi Rajnarayan, where the basic structure doctrine, we have applied this case. And after that, Minerva Mills also came, where we also applied basic structure doctrine. And finally, in 2007, 9-judge bench case came. I.R. Coelho very clearly said that basic structure doctrine is very important in judicial review, and Article 31B was introduced by the Parliament to remove the difficulties, not to wipe out the things which to Supreme say about saying that Supreme Court will not do judicial review. This was not the objective. So these are the basic features of Indian Constitution. Apart from this, I would like to say students who are present here that always top is always backend, so crowd is always at the bottom. Am I audible, Rajesh? Rajesh? नेट नहीं आ रहा क्या? Rajesh Singh has left the meeting. So I think Rajesh internet stopped working, I suppose.
Yeah, he just conveyed me.
Okay. So I have completed all the things. At last, I would say only to students. I think my voice is going to students. Is it going?
Yes, sir. Yes, sir.
I would say only at last 2-3 things after this lecture. That top is always backend, crowd is always at bottom. The rich rewards are never at the beginning of your career. and are only found near the top rung of the ladder.
Yes,
So,
sir, actually,
other than this, Rajesh, you left
sorry,
due to.
sorry, sir, my connection was lost.
Oh, I just
Sir,
I was feeling the same
yeah,
thing.
sir, it was very fantastic session. You have elaborated from Sankri Prasad.
I will take 2-3 minutes more just for
Okay,
students.
okay.
I was saying that for students, this is a message for students. Top is always vacant. The crowd is always at bottom. The rich rewards are never at the beginning of your career and are only found at the top rung of the ladder. Apart from this, I commend all the students to be argumentative, inquisitive, indignant, and apologetic, and get always be ready to accept criticism of yourself because this will ultimately help you to develop the art of persuasion. Thank you. Thank you very much.
Sir, it was very fantastic session by Rajiv sir. And sir, you have elaborated startingly from Sankri Prasad that has stated that you can change anything in the Indian Constitution. Any part of the Indian Constitution can be changed. Then you went to the Sankri Prasad and then Golaknath. Golaknath was specifically stated that you can change the fundamental right, but you cannot change you cannot change the fundamental rights. You can change
Yes,
the fundamental rights. Sorry.
You can change.
Yes, you can change the fundamental rights. And then you went to sir on Kesav Nanda Bharti, that the basic structure of the Indian Constitution. And thereafter, sir, you went to this Indira Nehru Narayan case. Then you went to Minerva Mill case, which has been very much specifically stated and explained in a very well manner. Then you went to IR Kolo case, which has been specifically stated that you cannot stop from any for the judicial review. Means if suppose the parliament is making any law, so that you cannot say that it cannot be retreated, you cannot be changed, and the judicial review is the process where the judicial review has a power. And you have explained in a very well way, sir. Sir, I have my student have few questions.
Yes, yes.
Sir, first that, sir, what is the concept of the constitutionalism in the IR Kolo case?
IR Kolo case, the main concept in case was this, that whether in when we say that any law which is parked in schedule 9, that cannot be changed, but that cannot be changed, so that this case refers to this case whether Supreme Court can do it or it is valid. So here the Supreme Court can say that you can do this also and it can be changed also. And Supreme Court not only this in NJC matter, this is a perfect example. In
Yes,
NJC
sir.
matter, which was which is passed by the
99th
parliament,
Amendment.
which was the part by the parliament, where Supreme Court is striking down of NJC 99th Amendment, terming it to be unconstitutional. So that is a very perfect example where Supreme Court held that no, you can't say that you have parked in Schedule 9, so we cannot do anything. We can do anything. And say we see that it's not proper. Even when establishing the upper limit of reservation to 50% in Indira Sahni case, that is also second example. When Supreme Court very clearly said, no, it doesn't mean that you have passed the law in schedule and capped in schedule 9, we cannot change it. We can change it also. So these 2-3 examples are there. So where you can understand how Supreme Court did this all things.
Sir, one more question, sir. In Indira Nehru Narayan case, sir, when the Honorable High Court has already means given the guidelines that the Indira Gandhi should be exempt, should not be applicable for the for this post. But you know what Indira Gandhi has amended, and she wanted all the power is with the parliament. So can you just elaborate that why this is so? Why Indira Gandhi want to do so?
So this question, Rajesh, is not of our field. This is something Parliament has done. Indira Gandhi has done this thing. We can only say that at the stage of Supreme Court and what High Court did. If you say High Court did this thing, then High Court before that emergency was down by Indira Gandhi.
Yes.
And if you have done something wrong or something right, then other party came to Supreme Court.
Yes.
So why she did this thing, we can't say anything on that.
Yeah.
She did wrong thing. That's why it has come to Supreme Court.
Yes, sir.
And
Yes.
Supreme Court finally decided the things and said it is unconstitutional. This is the other thing, that Indira Gandhi election was declared to be valid. This was some
Yes.
other thing.
Yes, sir. Yes, sir.
This is judicial cases. We can only assess what the judgment was passed. Why the judgment was passed, we cannot assess.
Sir, at the last, sir, we want that you can just give few tips that how the student will do the argument in the court for, or means for 2 to 3 minutes, sir. You can just give a few tips to our students. Sir.
Yes, I 100%ly I guide this, commend all the students. First, work hard and always be count your practice in your knowledge. Not that we have passed 20 years in practice. Maybe that you have done nothing in 20 years. You count your work, how many petitions you have drafted, how many work you have done, how many books you have learned, how many articles you have gone through, how many lectures you have attended, how many cases you have done. That is the practice, not this that we have passed 25 years in practice and
Yes.
we have 25 years experience. Maybe if somebody is having 5 years experience, maybe most worthy from you. He has done so many things. Secondly, always be physically fit. A lawyer should always be physically fit, always understand the value of the time and knowledge of command on English language. I will always say that always English command on English language. Read law books, always go through and update it with the new amendments, with the new Supreme Court judgments. As a lawyer, somebody asks you that what is the current law, you should know.
Yes.
Maybe that something was the law and now at this stage there is something law. And always a hobby, develop a hobby to do something, and addressing a judge is also very important. And the most important thing is ready to criticism of yourself. When somebody criticize you, that help you to develop the art of persuasion. So
Yes.
somebody is saying that, sir, you are wrong, and avoid annoyance and to clarify that no, we are not wrong. That is very important. When
Yes.
you will come in the legal field, there would be so many allegations on you. Maybe other side say something about you, maybe some said. So you should enjoy this thing. No,
Yes.
rather to get annoyed on him, you should simplify the things. No, that would help you in a persuasion. Always be inquisitive,
Yes.
indignant, and argumentative, and always be apologetic. I would say apologetic. So that nothing is going to happen in the court which is damaging you. So always, if you feel that the court is saying something, always be ready to apology. That is
Yes.
my always.
Sir, it was very fantastic session and you have elaborated in a very well way. Even though, sir, I am also means each and every line I've listened in a very careful manner, and you have elaborated with the important sections also. So it was very fantastic lecture, sir. And we already Dr. Akhil Sayed sir also told, sir, whenever you are in Gujarat, and we will invite you after this pandemic at our college, sir. If you will get the time, we will definitely invite you, sir, at our college, sir. So on the behalf of Parul Institute of Law, Parul University, sir, we are very much thankful for this valuable time. We have given a precious time for 1 hour. I know that every senior lawyer has very precious time, schedule tight. So I can understand, sir. So I am very much thankful to you, sir. So thank you to Mr. Jiten Kobhani, sir, also, who has taken this care event, because the live session is total taken care by him. So I'm thankful to Jiten sir also, and thankful to Brijesh sir also. So thank you, Rajiv sir. Thank you, sir. Thank you. Thanks a lot, sir. Thanks a lot.
Okay.